is discrimination because of your color, because of your ethnicity. I understand that you handle those too, so please, ladies and gentlemen, pay attention. Especialmente si ustedes hablan nuestro idioma español y son latino, it's very important for you to pay attention to this. Now, David, we're here talking about Fair Labor Standards Act.
Right.
But let's talk about discrimination, some of the cases you've handled there. Latinos, blacks, women, gender discrimination, and our counterparts that are white, Anglo-Saxon, Protestants, males, they sometimes, I see and hear, reverse discrimination, which I think is true. I think that they have been discriminated against in the inverse also. So you just don't have to be black or Hispanic, right?
Well, that's true, Joe. There is such thing as reverse discrimination. It's not real common, of course. Usually the folks that are being discriminated against are the minorities. And it's, let me tell you, there's been studies where groups will respond to jobs that are posted, and they will send the exact same resume to the potential employer. One resume will have a name on it that appears to be a white male. The other resume with the exact same qualifications has a name that identifies the person as a racial or an ethnic minority. That person is 50% less likely to be called for a job interview when all the qualifications are the same. So, unfortunately, discrimination is alive and well in this country, and there are lawyers, I'm one of them, I'm proud to be one of them, that I know I can't end it, I can do my part, but I can make the folks that are doing it pay for it.
What industries are you seeing this in that's very prominent? You know, I know a lot of Latinos down here in South Texas work oil field. I have heard of discrimination within the workplace, hostile work environment, racial slurs, things like that. But as far as being discriminated against, who are the big industries, which ones rather, are the big industries that you're seeing that this is impacting?
It's widespread. It's across the board. Unfortunately, it really doesn't differentiate from industry to industry. I think you probably see it more with the blue-collar folks, of course, service industries, people who provide labor, those sorts of people.
And when that happens, how hard is that to prove sometimes? I mean, you know, when you throw the race card out there, there's a lot of smoke screen where, no, we didn't do it because of that, we did it. I hear this again and again, even though I don't handle employment law. They said, well, they said that I was late. They said that I had other issues, but the other people that were not minority had the same issues, but they didn't get fired.
Right, absolutely, and that's a key point, because that's exactly what happens. Somebody makes a claim of discrimination because of their gender, age sometimes, their race, ethnicity, and they make the claim, and the employer says, oh no, we didn't terminate you, we didn't demote you, we didn't deny you this promotion because of your race. We did it because, like you said, well, you were late on these days, or this customer complained about you. Well, you know, the fact of the matter is nobody's perfect. Every employee is going to have something that an employer can complain about. And so the key is to determine whether what the employer is claiming to be the reason, is that a pretext or is it the truth? And the scenario you pointed out where you've got other employees who do the same thing, they're not minorities and they don't suffer these same consequences. So that's excellent, excellent evidence if it's there. But the other thing that you can do as a lawyer, like myself that represents employees, is to show, okay, well, maybe the employee did have a legitimate reason for this discipline, but race also played a part, and so you have what's called a mixed motive case. We don't have to prove that was the only reason, just that it was one of the reasons motivating the employer to take this adverse action.
And you bring out an interesting point, that mixed motive, I guess, is where we're going to see that A lot of people have the double whammy. I've gotten people that I've had to refer out over the years. Let's talk about an example of a Latina who is pregnant and who applied to a job, didn't tell them she was pregnant. 5 months later, she's showing, and the employer, I've had cases where the employer said, "You're slowing us down because of your pregnancy." By law, can they fire somebody for being pregnant?
No, see, now you're implicating various statutes. You've got Title VII, which is the law that says you can't discriminate because of gender. You've got the Pregnancy Discrimination Act, which says you can't discriminate because a person's pregnant. And lately there's been some question about whether even the Americans with Disabilities Act is involved in these types of cases. And so the answer is no, you can't discriminate against somebody because they're pregnant. You have to allow people to do their jobs. And simply because a person's pregnant, that's no reason to discriminate against them.
Now let's delve a little bit more into my example. If the person was compensating short of breath, maybe they were in a key sensitive job position where sleepiness, drowsiness, shortness of breath, swelling of the feet, things that are associated with pregnancy, how does that impact? And perhaps if the employer, I know there's very competent lawyers out there representing in companies that are board certified like yourself, so are they any affirmative defenses where they're saying, well, it's not because of the pregnancy itself, but because of the medical conditions it created that are endangering other workers?
Sure, absolutely. I mean, if there is a legitimate business-related reason to take whatever action it is, well, then employers are entitled to do those things, of course, within reason. So yeah, there are certain defenses like that are available to employers, and there should be.
But I guess the question I'm getting to is, what is the employer's duty if that person is very pregnant, congratulations, but at the same time they are not doing their complete job? Do they have a duty to accommodate that person?
Sure, yeah, under the Americans with Disabilities Act, if you have conditions other than just the pregnancy, things that are complicating the pregnancy and the health issues, then yeah, under the Americans with Disabilities Act, I believe the employer has a duty to make reasonable accommodations. If the person is constantly required to stand, if they can sit for a while, if they can take more breaks, if they can do that sort of thing, then the employer has a duty to accommodate those folks.
And we're staying within the confines of the Latino example that I was using also. There's mixed motives, as you said, sometimes. So it might be that the person was Latina, they were reluctant, but they hired anyway because they wanted to look diverse.
Right.
And then they find out she was, and what if somebody makes a comment like, well, you people are always making babies or things like that? What would that trigger?
Well, I think you would have multiple causes of action. You would have the Pregnancy Discrimination Act case, but I think your better case would probably be race discrimination under Title VII of the Civil Rights Act of 1964. It's intended to prevent discrimination against people because of gender, because of race, national origin, that sort of thing. That's probably the better case in that scenario because you have those comments that were made. And so that would be pretty good evidence for an employee.
Well, and I'm not a flaming liberal by any means, but I do see that law enforcement has underlined a lot of this in the news, that there are some treatment, you're 28 times as likely to be shot if you're an African-American male in this country, or you're, 1/3 of African-American males have been incarcerated on supervised release, things like that. So, as you said, it's alive and well. As an employer, how can you protect yourself? And then we'll switch back to employee, but employers, small business people who aren't lawyers, when they're hiring somebody, what can you or can you not ask when you hire somebody?
Okay, well, as far as the small employers, it's important to point out that Title VII applies to employers with 15 or more employees. It doesn't apply to the really, really small mom and pop types of establishments. When you're interviewing people, ask questions about things that are pertinent and relevant to the job, to the requirements and the skills required to perform the job. You know, if a person can do the job, what difference does it make when they were born? You know, if the person can do the job, if they have the skills, what difference does it make what their race is or their national origin? Those things are completely irrelevant. So ask questions that are pertinent about the job and the skills required to do that job.
If somebody poses a question without intentionally trying to trigger a certain response and says, well, we've got to pick up about 30 pounds sometimes, how are you going to do that? And if, say, our example of a Latino lady says, well, I'm 2 months pregnant, and I've had a high-risk pregnancy in the past with gestational diabetes, and I don't think I can lift those boxes, but it's because I'm pregnant. Now, pre-screening, pre-hiring, let's say they had 16 employees at a local restaurant. What is the duty then? They didn't trigger that response as an employer. I've had actual situations like that said, we didn't ask if she was pregnant, she volunteered it. And she said she couldn't do the job probably because she was pregnant, but we didn't want to not hire her just for the fact that she said she was pregnant.
Sure. Well, the employer's obligation is to make reasonable accommodations. If the job requires that an employee perform a certain skill and they're just simply not able to do it, well, the employer doesn't have to hire that employee.
Okay. So that, in other words, pre-screening and before hiring, as long as it's not a pretextual, I didn't hire you because you're pregnant, I didn't hire you for the reason that maybe you may not be able to fulfill the job requirement.
That's a legitimate business reason for making that decision.
Now, if the person comes back and says, the employee, they didn't hire me because I was pregnant, oh boy, hold on. That they said, I got the vibe that I wasn't hired just because I was pregnant. And, you know, two sides to a story. They come to a lawyer, they omit the fact that they said, I probably can't lift 30 pounds, high-risk pregnancy.
Right.
The truth's going to come out, right? I mean, through evidence and...
Well, probably what's going to happen, see, these cases, unlike the overtime cases, these cases are, the employee is required to file a charge with the EEOC for these discrimination cases, or one of the local agencies that enforces discrimination laws. And that agency will do an investigation. The employer will get a chance to respond. And then the EEOC will either pursue the claim or tell the employee, we're not going to pursue it for you. Here's a letter saying that you have a right to sue. You have to do it within 90 days. Well, they'll go to an attorney, and the attorney will look at it, and that information will be available. And in all likelihood, if that's a legitimate reason, most lawyers aren't going to take that case.
Okay.